Thank you everybody for your patience. I know we skipped the coffee break, but we have a really exciting panel for you, which will hopefully make up for the coffee break. And whoever sticks around till the end, the first round of beer will be on me. So if you need additional motivation to stick around. Okay. Um, so we have a very interesting panel for you coming up, and I think something that was discussed earlier in the day, the significance of the DPDP Act or the Privacy Act, how it's going to affect the Indian ecosystem. So we've assembled a very interesting panel. So if I could have the panelists come up. Now. I think how many were here for Gaurav's talk? How many? So you know about DPDP already, right? But just to give you a small glimpse, um, just a review. Okay, so the DPDP Act, which people call it as GDPR on steroids or GDPR version 2, which sort of started with public consultation in November 2022, went for cabinet approval in July 2023, and August 2023 it finally became a law. It was signed into law, and since then we've been waiting for rules of enforcement. So the law has been there; it's on the books, but uh, uh, it's not been enforced. We were supposed to have it enforced by September 28th, but now what we're hearing sometime around November perhaps. And what this law really does is provides you as citizens of India control over your data, right? So the ability to provide consent in multiple forms by anyone who's who's going to be processing your data and who's going to be using your data, who's going to be storing your data, right? So different aspects of it. So consent, the duties of data fiduciary, so people who actually control your data, special children's rights, and most importantly, grievance redressal, right? So if something goes wrong, how do you handle that? So again, so at a very high level, right? I mean, we'll have an entire panel to talk about it, but at a very high level, so what does consent mean, right? So data. So when data is collected from you, as of today, people are collecting data, and there's some notion of consent. Most people don't read, and things are not very clear on what they're collecting, what they're going to be using it for, right? So it's collecting data with a clear agreement of what it will be used for, right? Minimizing the data that can be collected. So only essential data, essential personal information, something that's actually required must be collected. The privacy notices should, and I think Gaurav did a fantastic job of explaining that, should make sense. People should actually pause over it, think about it, and actually, be able to understand what's in them. And easy access to correction if needed or removal if needed, right? There are some advanced aspects also, but we'll come to that within the panel. Okay, so we have a very esteemed set of panelists here, with us. So first, so starting from my very left, so we have Mr. Dipanjan, who's the Data Protection Officer of HDB Financial Services. We have Yashu Bansal, who's a legal scholar and a member of faculty at Manipal. We have Mr. Utkarsh Srivastava, who is the founder of Securelytix and doing secure APIs for several verticals. And then from the food delivery vertical, we have Mr. Fasihullah Askiri, who's the chief architect for security and privacy at Swiggy. Okay, so I will let the panel maybe just to start off, right? From each of the panelists, if I can get sort of, you introduce yourself and how do you interact, or what is your role in context of privacy on a daily basis? Need mics.
Journey in this started in this city. So in 2020, I joined an organization called Syngene over here, which is a biocon company which was doing work in the field of pharma. So it was COVID time, a lot of internal challenges, and a lot of pressures globally for quick delivery of clinical test trials. So privacy was one of the focus areas. And at that point of time, there was a lot of buzz around GDPR and CCPA. So my journey started from there, learning about privacy, implementing privacy within organization. So to give a quick introduction about myself, so I am a lawyer by profession, in this field of privacy for almost 6-7 years right now. Uh, I am masters in constitutional law and masters in cyber law, both. So it's basically a marriage of constitutional laws and tech laws. Privacy comes from constitutional notions. The primary foundation of privacy as a right comes from the UN Declaration of Human Rights. And from there, I mean, a lot of countries have picked it up. EU had a privacy directive, which was later converted into GDPR in 2018. India has also got a long history of privacy, but again, not as a law, but it is recognized by court in different case judgments, but not as a fundamental right. The first time it came into force as was recognized as a fundamental right was the Puttaswamy judgment, in which the court said privacy is also a fundamental right. But the principles of privacy were already there in Constitution. In several case judgments, it was already decided. Now, there was a bill which came up after the Puttaswamy judgment, but that was taken back in 2022 and a new draft was floated. And 2023, 11th August, I think, it became a law. Now, the law was discussed for long, and the rules came out this year in January. Until now, we are waiting for implementation of the rules. The rules have not been notified. Now, the question which my boss always asks me is, he used to ask me, when the law is coming. Now he asks, is the law coming? So this is a very tricky question, but I know that it will come, definitely. The first thing which I would like to say is, in India, in the eastern coast of India, it's prone to a lot of cyclonic activities, a lot of storms coming. And every year, at least 2-3 big cyclones hit the eastern coast. Sometimes in some years it's happened, there are news of cyclonic storms, but it gets diverted to Bangladesh or other parts. The Indian eastern coast is saved, but that does not stop the governments to take precautionary measures. The law is already there. The rules, the draft rules are already there. It might come sooner or later. That should not stop us from preparing for this storm. We should take measures right now and be prepared so that when the law is implemented, we don't do a catch-up job. Rather than we are already prepared for what comes next.
Next, Yashu, if you can have.
Yes, hi everyone. This is Yashu. So for me, I think I'm a lawyer as well. My interest in privacy and data protection I don't interchange them, privacy and data protection. Started when I was consulting, worked in-house, met founders who said, let's just collect location data. No one reads the terms. So, as a lawyer, you find it very questionable because it's unethical as well, right? And after that, I did a master's. I went to Europe, saw GDPR very closely, worked with startups in Europe which are trying to solve the problem. Not yet a success, but they're working towards it. And now that I'm back in the country, my day-to-day is with my students. I teach LLM in data privacy and IT. So I study privacy, I teach privacy day in, day out. And also I do consulting with some privacy compliance softwares where I work with clients. I'm trying to solve tough questions. Is this PII or not? Tough questions such as, do I need a DPIA? Because the law is vague. And as he also said, everyone's waiting for the rules. So I'm hoping the rules will bring more clarity. But I want to look at privacy from a larger perspective and not just data privacy. And hence, I'm very happy to be in this panel as well, for where we are talking about data for public good, where we might talk about data which is not personal data anymore, and how to get the best out of it.
Thank you.
Yeah, hi everyone. My name is Utkarsh. I run a data security SaaS startup based off India and US. And as we know that DPDP on the broader category, they have two aspects of the law, right? I think most of the people talks about consent everywhere, right? But we forget after you take consent that the most important, which is the fundamental process to protect the data inside the architecture, right? Which we call a data security posture management, right? DSPM, most of the places, right? So what we build, what we are solving is a massive engineering privacy architecture problem, where we helping all the major enterprises that stores and product data at large scale, right? So we are working on very interesting projects like with different healthcare companies, fintech, food delivery apps, who stores chunks of PI. Because as we know today, PI is everywhere, right? And this need to be protected at the core, right? And we have come up with a very interesting data vault architecture where we segregate all the API, which is lying in multiple locations. We keep it in a vault, and anyone who want to use the data, they can come to the vault and use it. And maybe you can enable safe computation of the data from the vault itself, right? So we follow data by blind kind of architecture where we are not storing any raw data inside the architecture. So there's a isolated place where you keep all the PI in one place. Anyone who want to use the data for certain use cases, maybe some AILM use cases, they can come to the vault and use that data accordingly. Yeah.
Hello everyone. I'm Fasih. I'm principal actor for Swiggy. I feel very underqualified compared to all of you. But Swiggy will likely be a significant data fiduciary. And as the one of the things that I look at is how do you give pragmatic engineering solutions to some of these problems, given that the law is not notified. For example, we don't necessarily Swiggy being a very data-driven company, we have a lot of use cases where people want access to data. So at best, at least go with the intention that you don't want to end up in cases where we will do a data abuse. So, like just being privacy first, respect people's privacy and come up with engineering solutions. For example, we had also looked at this data vault kind of solutions. So looking at what are the pragmatic engineering solutions that will get us to a place where at least I don't think of it as a storm. I think of it as get us to a place where we don't end up abusing people's privacy, because I really feel that being a significant data fiduciary is like a significant responsibility. So just make sure that from an engineering perspective, we are in a place where we respect people's privacy and don't end up, like leaking these things or abusing these things, even when we intend to do good. Right. So yeah, so that's what I want to add one thing.
So to sum up, like there's no data privacy without data security. So you need to learn how to protect, even after taking consent, if you don't protect the data and keep leaking the data, you will lose the customer rate. The customer is most important than taking consent. Consent is first place, but securing data, protecting it is the most important than anything else.
Okay. So one thing maybe, I think you already mentioned, and all of you have already mentioned that the law is getting delayed, right? Now, as a big company, I think we have two big companies, and I think a lot of your customers, who are probably big companies. How do you prepare for this? How do you prepare for this uncertainty? How are you dealing with it? Is it like your boss just doesn't care and will cut all the budgets and use it for beer money or something? So how are big companies dealing? Because the way I see it is, as large data fiduciaries, right, the impact of this on your day-to-day business could be huge. So how are you preparing for it, and what's the general feeling inside?
First of all, if you want to protect your data, first you should know what data you hold. So you need to do a data discovery. That's the primary. It's very technical, but again, that's the primary basis. I do it myself. Because if I don't know it myself, where data lies, structured, unstructured, then it will be very difficult for me to draft the policies, to draft a privacy notice, because I need to know what is the purpose for which each data is being collected. And I work for an NBFC. In the financial sector, there are a lot of data which is being collected, and there are separate purposes. There's a lot of APIs being run. So the ideal position for a DPO is you should know where the data is going, who all have access, what are the purposes for which you're collecting. Now, when DPDP will come, we have to have separate consent mechanism over here. So, there will be something for you anyway do KYC, but for marketing, promotion, somebody who has already taken a loan, I might offer him an additional loan during Diwali. So, do I have the consent for that? If I'm clubbing everything right now, the law does not allow me. At present, there is no law. You still can club. But once the law is implemented, you have to have a granular consent. you have to, for promotional offers, you have to have a separate button where that should not be pre-checked in. The customer should proactively check in the box, say, I want to be contacted, maybe by SMS, email, WhatsApp. That has to be segregated. And once you capture that consent, you also have to give that withdrawal mechanism. So to understand that, the first primary objective is to do a data discovery and link it to the purpose for which it is being collected. And in today's organizations, it's all data driven. Finance companies, fintechs are all data driven. You need to understand where my sales are going up, in which region, during what time, and what are the choices, what are the offers people are looking for. I have a fintech company and I'm an NBFC. I want to fund in a particular region. Which fintech is strong? What type of data they are holding? Can we do a data room exercise? Now, data room exercise will require both companies sharing data and check what is the match percentage. And then identify, do we have a common offer? So these will require a data discovery exercise, first of all, then mapping those with your purposes. Identify, are you collecting excess data? Anything which is excess violates data minimization. And when you link it to the purposes, you define purpose limitation. And then your policies, your procedures, your privacy notices, this will come. But the primary work is this, and that is going on. So this is a very silent work. It is not a flashy activity which will come in public. You will see a lot of banners, privacy notices, policies coming up. That won't happen. This is a very silent work that is happening inside within the organization, speaking to each team. Teams have sub-teams, sub-verticals. So even we have sales finance. Sales finance would have a product team. It will have an asset finance, a marketing team. So you need to speak to each team and understand what are their data needs and create a register. We call it ROPA, Record of Processing Activities. You create a ROPA for that. And that ROPA will track the entire journey of that data, a single data set, how it is being collected. Do you require consent? Do you have consent? Do you require consent? Or you can still process it without even consent. There are certain data that can be processed even without consent. For example, debt collection. Debt collection can be processed even without customer's consent. So we have to identify each set of data, link it to the purposes, understand whether we are collecting additional data which is not required. If repurposing has to be done, we require this data for additional purposes. In that case, there is a case, strong case that we need to go back to the customer and take a consent. So these mapping exercise is going on. Identify high risk activities. Conduct a DPIA for those, data protection impact assessment. Other countries, I mean, most probably in US, they call it PIA, privacy impact assessment. Here, we do a data protection impact assessment. These two terms are almost similar, but there is slight difference. We look at from a technical organizational controls also. So, I mean, privacy is more of a US type of thing, and data protection is what the law requires. So it's not only consent and privacy notices, but also you protect the data that you're collecting. So that's the work that as of now going on. Most organizations are probably doing it. And another aspect is a data protection officer himself or herself cannot manage the entire company's data governance. You need to have stakeholders who will be accountable for each vertical's data. So you need to identify data champions within each vertical where you will entrust some responsibility for them to do this ROPA, update this ROPA annually, help them on conducting DPIAs. And this is a silent work. And this will take some amount of time before you build up compliance.
On Swiggy, what are you guys doing on this side?
Sorry. So on our side, one of the primary things we started doing was just building the awareness. So specifically because the context that I was saying that we are a very data first kind of a company. So just to make sure that various businesses, operations, marketing kind of understands that there is a data privacy where it matters for people. I'll give you a simple example. So there is an offer that we give out to restaurants wherein they can take a credit line for buying stuff from Instamart, right? Like it's a product line that we run. Now, for this, from the product team's perspective, it is something that everybody should be happy getting a credit line to buy stuff. But when we did this session, it turns out that not everybody might be interested. The product team basically reached out saying that this kind of thing where we want to do good, should we even talk to these people? And the answer was, of course, yes, right? Because you should care for their privacy. So I think that is something that, because the law sometimes just looks too gory. Similar thing was right to forget, where, like you think that product team typically thinks that right to forget implies that you are making the process of offboarding from the platform easier. But at the end of the day, I think it takes a while for people to imbibe the concept that it is just a fundamental right that we should be able to forget them and what it means, right? So these are on the awareness perspective. There's one important project that I'm running currently is because we started before India had the Mumbai data center, we are on AWS. So most of our infrastructure used to run in Singapore. So we are running an active project to migrate all the infrastructure to Mumbai. So that is something towards the preparation. We're pretty sure as of now that probably that is not it might not be required, but just in preparation, and it is something that will anyways be operationally and uptime wise a little better. So we are prioritizing these kind of projects where we feel that it will have an impact on DPDP, and it might also help us improve our uptimes, right? But other than the data collection, the data discovery bit, I think the awareness is something that at least personally I've found helped a lot. People start realizing that, I think it takes a lot of time for people to realize that this is also a thing that I should take care of.
And are you, I mean, from your perspective, I mean, are you working with customers for this, or what's the?
So the biggest problem we see when we're talking to larger customers storing chunks of data today is, as you rightly said by him, right? A lot of company doesn't know where the data is lying. So data is lying in multiple places, right? The prob the problem today with the architecture is like, the scattering of data, right? Data is being sprawled or distributed into different places, right? So this architecture is very difficult or very hard to manage, right? Or even to keep it compliant. So what we do, like how we are helping, we are discovering is the first journey, right? Where you discover all the data, where the structured, unstructured, across the data pipeline, where there's the AI, where the data lakes, everywhere. You pull all the data, keep it in a vault, in isolated space, and it is very easy to manage centrally and govern it. The life becomes very easy compared to the scattered model, right?
Yes.
I think
Do-
every point is covered here, starting from discovery, scanning to training,
Production.
and of course, I think one more thing is the governance aspect. I'm seeing companies have started, as you mentioned, data champions. So they've now started thinking about their policies, how to document those policies. And I would also really like to emphasize on training, because like I'm also giving training to companies. People don't realize that they are even touching PIIs there. For them, it's just basic data. But again, the rules, in my opinion, will only play the role of filling in the blanks, right? There can be more procedural things around the rules, but I think in India, companies are not investing right now. It's tough to get into the market where people want to purchase and invest money and time in this. But some companies have already started working on it. So I'm hopeful that by next year we'll see something positive.
So actually, one thing that both of you mentioned, so I've seen this in Indian context a lot, that companies tend to, I mean, a lot of business is generated from add-on services, right? So Swiggy offers credit cards, and as a result of that, there's a lot of broad consent for when consent is taken, it's very broad, right? Whereas the law will make the consent very purpose limited, right?
And I mean, I've personally experienced this. I mean, just last weekend, I was trying to book a ticket, and the one of
The big websites which helps you book tickets is asking for my PAN number for booking a domestic ticket, right? There is absolutely no reason why that information is needed, right? Or
I mean, even Swiggy, while applying for a credit card, asks for your PAN number, whereas HDFC should ideally be having information like that, right? So there's a
very
very
broad lesson that's taken, and people, people who are not necessarily digitally literate,
would actually end up giving that consent also. So I'm curious, from a business side, do you see your business models fundamentally changing, reduction of these add-on services, or are you going to be sort of finding different ways of collecting consent uh, once the law is passed?
Quick plug. So at least for the PAN card thing, so this is something that we don't touch the PAN card. So it is transparently passed through to HDFC. I think that is the primary role that I play, looking at whenever these kind of things come up, because of those awareness things, people will invariably ask that question, can we do this? And the answer is no, you cannot. And so at least for consumers, we don't store anything of like PAN card, definitely not, your credit card, etc. Because the moment you touch that, you know that it is like a significantly additional responsibility we have to take. And I think that's where this awareness thing comes in. On the question of do we think that businesses will do less of additional services, I think the answer to that is definitely, at least to my mind, definitely no. What will instead happen is for example, the credit line case that I was talking about, for that matter, we also offer our delivery partners insurance. So for these cases, till some time back, the insurance, the way it was offered was the numbers of delivery partners used to be shared with these insurance agencies, thinking that, of course, we want to do good by them. We want to say that the insurance should be available to the delivery partners and we would share the data. But after this, like sessions we had, one of the things that bubbled up in that data discovery process was, this is a transaction that we do where we push our delivery partner numbers to this insurance, and we obviously don't, the way we share it, we don't have like a good track of where it is going. And did the delivery partner actually consent to getting that insurance, because it is not required, specifically if you're not an employee, right? Like there are these gig partners kind of people. So then we kind of modified these things to say that take a consent. If they don't consent, if they don't explicitly say that I want an insurance, which will mean that my data will be shared with, just that one line that says that I want insurance. If I get the insurance, my data will be shared with an insurance partner in local languages as well. Then you don't do it, right? So things like that is what, even if, so I just wanted to add there that some of this, we are not strictly going by law. For example, you click that, it is not stored somewhere, right? Like, I hope that's not law, right? So it's not stored somewhere, and it is obviously not a requirement yet. But we make sure that the person clicks, right? But if you were to ask me, when did the person click? We are not recording it, because at least from my perspective, we are saying that the intent that the person has clicked is there. Without clicking, they will not be able to get it. But from a legal perspective, to be able to track that this time the person has clicked, that we have not implemented, right? So I think it is about, we have the right intent, but some of this we may not be going by strictly by the letter. The letter is not there also.
Can I ask question? Can I also ask question?
Wait, we'll just
See, I have
one more comment and then
I have
you
a
can
simple
ask
answer
it.
for it. In a city, there are two restaurants. One provides only thali. You will find customers going to that restaurant. And there is a restaurant which provides a la carte. They will provide a menu card, you can choose it. Now you go to that first restaurant, you'll get thali, you will get dal, sabzi, you will get pickle, you will get curd, you will get sabzi, everything. And you don't have a choice to choose it. You have to take it, and because you're paid for it. You cannot say that, no, I don't want this. Anyway, you'll have to have that. In the next restaurant, you will get a menu card. So you can see what you want and decide, I want this, 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 this. So the movement of the present system to DPDP is this, from thali to a menu card, where you decide what you want, what consent you're giving, how you want your data to be utilized. So both the restaurants do business. So business is not going to go away. Now companies are more diligent. Even customers will also be diligent about sharing the data. Not every data is required today, but companies do collect, thinking that in future it might be useful. But now companies will also be careful that additional data collection will also lead to violations, bringing penalty. So just assuming some data will be useful 50 years later, they won't collect that data. They will think twice before collecting something, and they will ask for consent from the customer and give them the opportunity to withdraw also. And surprisingly, DPDP has not been implemented. A lot of companies are getting request of withdrawal to the DPOs, to the customer service, on call and over email. So they are calling up customer care and say, I want to withdraw my consent, or writing to the DPOs. And this is being happening from 2023 when DPDP Act was, enacted.
That's great, actually. It's
I've seen it myself. So it comes in bulk.
Yeah, same for us. We get a lot of requests.
I saw one in 2019. The person was like, it's in Europe, I also wander. And fine, it's a constitutional right at the end of the day, right? So yeah, we are seeing it. But I'll comment on consent here. While of course, Swiggy, I would like to know how would you withdraw / modify consent. Maybe in the future we'll have to work on that. But the entire issue is you can do all consent records from law. You can make it granular, you can make it leveled, you can make it explicit. But the main issue is with the word informed, right? Until unless the user, the data principal does not understand anything, they will consent on a terms of service which they are not even reading. So what's the real point of anything then, right? Why are we doing all this hassle? So I think the real call here, and which needs a lot more investment, maybe from private players as well, we are seeing some companies who are doing a lot of marketing and promotion around data privacy. Apple has a lot of interesting ads around it. Apple is telling people what is privacy enhancing tech, right? Maybe we need more awareness on that first, where people can really read those terms. We need some regulation by design there, some kind of ideas such as, which mandate you to click on a terms, otherwise you cannot consent, something like that. I have seen some apps do that. If you don't open the hyperlink, you cannot do the tick mark as well. So that's kind of pushing me, nudging me to open the terms. So until we do that, there's no point of all the consent management thing under the law.
Privacy, they use the legal term, right?
Exactly.
So they use the simplified version, right?
Yes.
So maybe since you touched on the informed side of it, right? So maybe on that. So there's been a lot of research done on this with GDPR. There have been a lot of academic papers which have come out. Like even the color of the lock in the cookie banner can actually influence the way people interpret it, right? People's perception about the privacy stuff, right? So I'm curious. So there is clearly a very large UX aspect of collecting consent and managing consent, right? So from a company point of view, if I have to ask maybe both of you, like how much investment does your company do on the UX side of collecting consent?
I'll answer that first. There is a term called privacy zookering. If anybody knows, I don't want to explain that, but if anybody knows, let it be like that. You'll find the privacy notice is there, but you have to do a research to find out where the privacy notice is there in the entire website. It's a dark pattern.
Right.
So, if this is the time of UX you're developing, you're doing a tick mark to the checklist, but actually the customer is not getting the benefit. So informed consent means you need to, make it visible to the customer, and customer can freely give a choice. The purpose of consent is not to agree or disagree, but give a choice. Can he still use the service by declining even? Right? Certain aspects are there. For example, if they don't give KYC consent, loan cannot be processed. That's for sure. But he can still move away with the loan without checking in future contact offers and promotional marketing emails. He can still move ahead with that. So that is the type of UX that needs to be developed. Pre-check boxes. I have seen still now a lot of companies, apps are using pre-check boxes for customers, making it easy for customers. Customers have to proactively uncheck it. Who does that? So ideal position is the UX should be customer friendly. That's the purpose of the concept of privacy by design is to make it customer and user friendly, not company friendly. So do not create dark patterns, make it more easier for the customers to use.
Yeah, of course. I have just started a project on fighting dark patterns under my law school center for research. So I think I'll start this by saying that there's a very thin line between dark patterns and innovative and creative marketing. And that thin line is what law policy they have to look into. Recently, Ministry of Consumer Affairs has a guideline on it. There was advisory also. Zepto did a lot of cleaning up after the advisory in June this year. But I think with dark patterns, I completely agree with him. I'm doing a very deep study on dark patterns. It's mainly influenced by US and Europe. In India, it's a very new thing because of course we are still trying to explain to people what is data privacy. right? We still have a very complicated even tabs with respect to cookie ban, as you mentioned, right? Reject non-essential cookies. You have negative connotations there. So it is tough. But for dark patterns, I believe that there has to be the end goal should be user autonomy. You have to give a user a free choice. There's a difference between nudge and sludge. Nudging someone to do something positive is good. For example, when I buy an insurance on Acco gives nudges me, hey Ashut, why don't you take a third party insurance also? It will be helpful for you. I get that, it's for my benefit. But when I'm on Swiggy and Swiggy is like, order right now, otherwise the offer will expire. I'm like, dude, don't pressurize me. I'm so sorry. Swiggy is my first database. I'm building a lot. I have an entire database on Swiggy dark patterns. But it's not all dark patterns. Some of them might be just creative marketing, innovative marketing. So that's what in my capacity as an academician and legal scholar, I would get into it whether it is really against the law or is it just marketing tactics.
Even rewarding customers for giving consent. Give consent and 50 coins in your bucket, in your points bucket.
Yeah, actually, that's
These are certain.
that's
these
a whole
are,
different
yeah.
that's a whole different economy to be get.
Correct.
We'll come to that.
Correct.
We'll come to that. But maybe since you mentioned Swiggy, just Swiggy.
No, it's okay. Okay, so market dark patterns around pushing people to nudge something I typically is something that I kind of stay away from because I'm basically it is something that like marketing business is I'll not go there, but at least from a privacy perspective we are very conscious. So to that question about do we if the user doesn't click, I will not get the service. Specifically questions like that, right? For example, a restaurant can choose to say that I want to get this cheaper products from Instrument because restaurant partners get some discount, but choose to say that I don't want credit line, which will automatically mean that the data is not going to be shared with. So we partner with NBFCs who actually extend the credit. So they don't choose it, they don't get the credit. So those kind of things we are particular about, specifically around the privacy bit of it, where, or for that matter, delivery executives can definitely say that they don't want insurance and the data will not be shared, but they can do business, right? Like they can earn, just that they don't want insurance for whatever reasons. Right? So for those kind of things, we are at least on the privacy side, mostly because I think Swiggy is a company kind of, I feel that cares for the consumers and the delivery executives as well. So I think that is something that at least I personally take pride in, that being privacy first is something that Swiggy does good job at.
You have something to add?
Yeah, so what I'm saying is, see, we have to also understand, a lot of people talking about consent all the time. It becomes very difficult for a company to survive without data because at the end of the day, you need data to build use cases. Maybe you need data to serve customer better, right? So what we focus on, you collect data. At the same time, you learn how to protect it within the architecture. Safe compute, right? How can you enable safe analytics, right, without exposing the raw data, right? You can still run user analytics without disclosing or exposing the raw data. That's what we are working on, the safe analytics. Let's take an example of AI. So today, a lot of companies building different AI agents, integrated with the OpenAI LLMs, right? And there you are pumping a lot of PIs. And the major problem with once you feed the PI into the LLM, there's no button to delete that PI, right? So what we do, we are putting a privacy filter between the LLM and the prompt, right, in the AI application. So my privacy that vault acts as a filter that filters the PI. We tokenize the PI, anonymize the data, and then send the PI and the transaction data to the LLM. Then LLM do all the reasoning and generates the output, and we can decode on the other side of the customer. This is how you safely compute. So we are not blocking data. You can still retain all the use cases without compromising the security of the data. Okay. So we are not stopping any company to collect less data because data is required to serve customer much better way. The more data points you have,
Right.
you can make more good use cases, better serve customer. Yeah.
So I just want to know, you mentioned this secure computes, or I would also say aggregations. So what does the law actually say? What does DPDP say? Say, for example, can Swiggy or anybody else, maybe you don't want to answer that. Can you release aggregated data without taking consents? Because I'm anonymizing it and releasing it. Can we do that? Or can, if I'm a data fiduciary and I am releasing data into a secure compute where there is a guarantee that the data won't go out, what does the law say about it? Just the law.
Do you want to highlight the law?
I actually, I think they are better.
On
The
the law,
legal
yeah.
scholar can actually comment on that.
Not regulatory, one engineer, lawyer. But yes, I will take that question from you. I think so. In Europe, what they have done is they have proper documents, like huge documents on anonymization, pseudonymization, and they stand under the law, protection-wise. In India, we don't have that yet. There's, however, the word anonymized mentioned in the law, the BEAR Act. But what I am of the opinion, in my opinion, if your data, there's no PII elements, you cannot trace back to an individual. And you mentioned with a guarantee that it cannot be reversed. If there's a technical guarantee that it cannot be reversed, it should not come under DPDP.
I mean, that's a very hard part. Even if you remove the name, you can always trace it back. And then it becomes very hard. There is no 100%.
And there's always a challenge of inference data also, right? You can have all aggregated data sets. There's a very interesting paper 2015 on things your doctor and many others may know.
Yeah.
There was you read that, right? It was aggregated data, but the person could link it from a newspaper article, which hospital, what time, what day, and the hospital data. So that's a challenge, but I feel that we should not go so strong.
The rules will be notified in a month.
So,
Rules will not talk about all this.
No. See, there are two aspects. One is pseudonymized data and one is anonymized data. Pseudonymized data is key-coded data. One is the key and one is the data. The data does not have any PII. But the key, through the key you can identify. Till probably a few months back, in Europe and in EU, pseudonymized data was considered as PII. Recent judgment came out that pseudonymized data with the controller is not PII if the key is not shared with the vendor. Vendor only has the data, not the key codes. It is not PII. So it does not require the same level of protection. Anonymized data is data which is completely free from PII. You cannot re-identify the data principal from the data subject. So it loses the PII character. So you can use anonymized data provided the anonymization is complete and you cannot re-identify the individual. So that is the catch, that a company using aggregated data must ensure that the PII aspect has completely been removed and it cannot be realigned. Data masking, encryption, this does not ensure anonymization. People think I have encrypted data, I have hashed data, that means I have anonymized data. It's not the case.
Yeah. So
how misconception.
So how do we do it? So the problem with encryption today is encryption always comes with the key, right? If you can get the key, you can get the data, right? Yeah.
Aggregation.
Anonymization is different levels, right? So the problem is that what parameters do I pick, right? So today I'm really confused, right? I can remove all PII elements. I can even remove indirect PII elements. Still it can be traced back. So I mean, unless these directions come out very clearly, I think it's going to be very confusing, right? So
I think, Shalabh, I'm sorry if I'm overstepping, but this is a good point because use cases for that kind of data set is mainly for data for public good, right? And then
policy research.
Yeah. And that has a clear exemption under DPDP. So if you're collecting processing data for research, statistics, archival purposes, you don't have to think about DPDP and the government will provide another set of rules, governance standards for this.
So-
that
No, no.
solves our problem, right?
So maybe actually since we're on that point, so maybe just to add to that, right? So, I mean, data for research is fine. It will come under an exception, right? But DPDP explicitly doesn't sort of differentiate. I mean, there's these very large data fiduciaries, yes, but it doesn't necessarily differentiate between, it doesn't exempt small businesses, right? So, I mean, even data for public good, for example, I mean, the organization which wants to do good, but not all data, not all use cases will be research based, for example.
Is it government to government? I know government to government is exempted.
But no. So even governments are not exempted. Actually, there is. So even states would not be exempted from this, right? So even neighborhood Kiryana shops, right? So that I send my photo to get it printed. I WhatsApp him my photo. He adjusts it, and he's actually processing my PII data, right? So even they're not exempted. So, do you think, I mean, that small businesses or, or non-profits like our Data for Public Good Center will be unnecessarily burdened as a result of this law, right? Um,
I will start and then maybe you can give me a little business perspective here. See, research, I will not combine business and Center for Public Good, which is more with research. But if I talk about small businesses, there's a very, very high chance that startups, small businesses will get an exemption. You will get an exemption with certain rules and rights. For example, let's say that if you're a small business, you might not have to comply with data subject access rights, data principle we call them here, or you might not have to deal with right to erasure. So the government will do it in a way because I'm very, very sure that in our country right now, the balance is more towards business and innovation. We're not taking the Europe approach here. We're not going very high on regulation. We're not going US way as well. I think we're finding our middle sweet spot, which will be more towards innovation, not burdening businesses. Because as yesterday also in our keynote, there was a speaker who mentioned about the Indian model of privacy. Right? You and I don't care about this when I send the PDF WhatsApp into my Xerox guy. It's about the convenience that I'm in my car, he gives me the printout, I go, right? So I think this Indian model of privacy will develop and the law will be in sync with it.
Even these small shoppers don't have a tech to manage those infrastructure, right? And if you look at the mid-cap market, like small SMEs, they use some sort of third-party billing ERPs of this, right? So what you can do, maximum, you can embed privacy at that data layer, right? Instead of enabling tech shops and the shopkeepers, right?
So maybe just to add to that, so I mean, assuming if the exemption comes and if there's separate rules, it's good. But in case it doesn't, right? So let's imagine Swiggy 10 years ago or HDB Finance 10 years ago, right? Do you think when the companies were small and sort of growing to the scale where they are, if these laws were stringent and enacted at that time, would that have hampered innovation or would that have sort of limited what the companies are doing right now?
Very sure it would have. Mostly because I think that I think every company goes through a stage of development where, like at some point of time, you have to move fast. And there is a stage where you realize that moving fast, you are at a stage where like the cost of breaking kind of considerably increases after you reach a certain scale. So if you're small, let's say tomorrow I put a restriction that, the Xerox people cannot take my data retention, which means that they'll have to be audited. Just imagine the kind of regulatory hassle that, forget the small, the Xerox people, right? Like even a company like Printo will start suffering because now they will have to not only implement that retention, but also have to make sure that they're externally audited because who will trust them, right? So I think all that will just add to slow down a lot of things. I think it makes most sense to say that at some point where the blast radius of that damage increases to a certain point, that is when the cost of increase their cost because that the blast radius is high. Otherwise, I think it is too much of a. Pretty sure that for a company like Swiggy, it will be like a dead on arrival kind of a thing. You just can't do business at that point.
I have a different perspective. I mean, we need to understand the spirit of the law. I mean, to whom this law actually is intended? Is it intended the Sharma ji ka Xerox center at my gully, or is it big companies, tech companies using data? And is there a penalty on this Xerox shops? 50 crores, I mean, that's the minimum. I mean, who is going to pay that? And there is no criminalization also of this. So nobody is going to jail. So most probably, these are not targeted. That Information Technology Act came in 2000. 2008, the first amendment came. And 2011, the SPDI rules came out. So it took 3 years for the government to come out with a set of rules, identify which is sensitive personal data. So, I mean, this law will evolve. This is the starting point. So, even GDPR also, I mean, over a period of time, they changed. After the Schramm's judgment, they changed. They changed the entire model of standard contractual clauses. And now they have got a new format altogether. They have included transfer impact assessment, transferring data outside European Union. So these are, I mean, use cases which will get developed over a period of time. Even courts, judiciary will have a lot of inputs over there. A lot of inputs will come from experts as well. Over a period of time, this law will evolve. We don't have anything today. We are having something. Whether there will be rules for these small companies or Xerox shops, that is something which we have to see later. But right now, the way data is being used, I mean, that is enormous. And there should be laws, regulations to, I mean, control that, to govern that. Now, coming to the question whether this will, I mean, stop innovations, stop the business, slow down business, I have one answer for this. If Google would have come in Europe after GDPR, do you think we won't have any Google Maps? We will have. They would have certain controls. Now they have the controls, right? They are putting those controls. And this is about putting controls. And it is not the business who is developing controls. People like us, there are a lot of people, experts are there, who is a separate team who are trying to innovate new things and incorporate it into the existing framework. Like consent management.
So, but that's the thing. So actually, a lot of, I mean, in Europe, actually, particularly, this is a running joke that if Google Maps were to be developed, it probably would not have developed because people would be too scared to even think about it. So doing it post facto versus thinking about complying is two different things, right? But so I want to open it up to the audience. Does the audience have any question? You are. We will hold your question at the end and give others a chance.
Hello. I have a question for any of the panel members. So, do you think Singapore's Personal Data Protection Act, PDPA 2012, represents a more balanced and progressive approach vis-a-vis DPDP Act of India or GDPR of European Union?
I have gone through it, but I think the main thing would be about implementation. Because see, Singapore is also a very business-friendly company, right? Country, right? Their laws also, when it comes to them, they are doing a phased implementation. If you think about it, so they're giving so much time to businesses. They're giving so much windows to businesses to gradually implement every provision they have. The laws are pretty much same. A little bit of terminology here and there, maybe one right lesson more, like how in GDPR you have data portability, we don't have it. But otherwise, I think the essence lies in execution and not the provisions here.
So I would like to raise a question in connection to basically the aspect of implication, I mean the implementation, whereas I would like to focus on technology questions. Now there is a right for all the data principles, that is right to erase. Now let's say that tomorrow I request for a right to erase. How will that mean? There is a technical standard for a verification that all the data that I have collected is erased from your whole system. What is the verification that I will be getting as a data principal that I have no data about mine in your? That's my question.
I can answer that because I deal with that every day. See, right to erasure is a limited right. Now, every organization needs to store data for a certain period of time based on regulations. That will anyway be there. Now, for certain purposes, it can be deleted. There is something called archival. Archival is there. When you send a request to the DPO, that request will have some personal information. There will be identity verification. You need to verify your identity. Are you the right person? That data will be stored with the DPO for example 8 years minimum. So some amount of data will still be there. The DPO will write back to you stating that we have, found out that this is the data we hold, and if there are no regulatory requirements, we will delete the data and will send you a notification that data has been deleted. If you have a grievance, you can revert back to the grievance redressal committee or the forum of that organization. If you are not satisfied with the answer, they will revert back. And even if you are not satisfied, then you can go to the data protection board. This is the format which the law provides. And DPO will write back to you that data has been deleted. Now, this is probably a certification from the DPO. And you have to take it in writing. If you are not satisfied with that, you can go to the grievance committee. If they want to provide a log of that, they can provide a log. Or else, if you still are not satisfied, the data protection board is always open.
But how do you technically verify?
Yeah, actually, that's what I was getting to. That I think that at some point in time, so forget the technical verification. To be able to say that the data is truly deleted, is impossible. Like it is just not possible to say that you raise a request for deletion and the data is gone from the system. I'll tell you some practical limitations. Let's say you have ordered on Swiggy. At some point of time, Swiggy must have pushed your the SHA, right? Like basically your hash to Google YouTube advertisements saying that I want to push this person this ad. So YouTube does not know about you, but it knows about your hash. So hash is on your phone number. Now, when you raise a request for erasure, I tell YouTube that this particular hash, because I have hashes, has requested for a erasure. So I can't go verify with YouTube what is it that they have deleted, but realize that the hashes are reversible because it's phone numbers, right? Like there are only 2 to the 10 to the power 10 phone numbers, smaller subset because numbers are limited. So if YouTube's data were leaked, which would tell you, imagine that they have not truly deleted the data, you can figure out that your phone number has been targeted these many ads and they can know about you. So technically it is like impossible to say that I have truly deleted you from everywhere that you are there. So at some point in time, you just have to kind of, like it is a best effort is what I can say. Like best effort to the sense that I will make sure that I have deleted it from my systems. If I have a vault, I will break the vault links. But to be able to say that it is truly deleted
At some
is...
point you may have learned from that data, then that becomes even harder to.
Yeah, actually, I wanted to take that I don't think that aggregated data, at least for a company like Swiggy, right? Like to us, it is not just about, so we have two primary concerns. One is this PII, and the second is, because we're a public company, we have something called UPSI, unpublished sensitive price information, unpublished price sensitive information, right? So that is basically, we cannot publish, let's say, what is the business done in, let's say, Bangalore region last month, because that might impact. So even though it does not, so let's say there is some data that tells you that this delivery executive has made this much in earnings. I cannot publish that because that is useful for somebody to predict how much business we have done in a particular region. So for all the data sharing we do, it is not just PI. Those are the primary two things we look at. So for us, data sharing typically always requires us to ask that question. Is it PI sensitive? It is UPSI. Can this be used to trace back some information that might affect our, like markets? So.
Okay. Any other audience question? Who wants to address that?
No, I think it's a very tough question because we recently had a panel where we had someone from Nimhans there, someone from Ava AD there. Ava was there. The entire issue is they don't understand consent. So my takeaway in this domain, health and consent, is that we should bifurcate consent at least majorly two sections. One is consent to provide healthcare. Sometimes you need healthcare assistance instantly. So I do not want to rely on consent there or bring that consent under the entire legal ambit of GDPR, DPDPA. And another can be processing. Because of course private hospitals do a lot of processing as well. I go to one hospital, see one doctor, and suddenly I get a lot of messages from everyone else like in the domain. But I completely agree with you that consent is a very big challenge in healthcare, and as I was saying earlier, it's about information. You have to spread awareness to people, to like at the ground level, at the grassroots level, where everyone understands the value of their consent. If I don't value my consent, how can I expect private companies to value my consent?
No, I have a point over here. I have been in pharma companies, so I know this. I have faced this earlier also. Now, somebody who is coming for treatment, I mean, you don't require a consent for that. I mean, that is anyway exempted under DPDP, even under GDPR also. That is for health. So, I mean, unless you are asking certain personal information, you won't be able to treat that person, right? So that data will be anywhere there. Now, in US, they have a law called HIPAA. The information, health information about the patient and the doctor is confidential between two parties. You cannot put it to a public platform. So there are laws around that. In DPDP also, I mean, if somebody is coming for treatment, you will collect that data. You cannot sell it to Insurance companies, you cannot send it to medical pharmacies or pharma companies for clinical trials. So, I mean, that won't require a consent. Yes, where it will be a case of consent, somewhere you are doing clinical trials, you call 10 people and do clinical trials. In that cases, you require samples from that person. And in that case, you have to have a clear consent that this data will be used. Their names may not come out, but at least the samples will be used, belong to them. And utmost protection must be given to the data when it is shared with third parties or the clients anywhere in the world. So, I mean, that consent should always be there and it should be clearly explained. Privacy notice should be in the language in which the person understands. I mean, it's not should be English. They won't understand. You just have a signature. That is not consent. That is not informed consent also. So maybe there you would require a clear consent, but coming for treatment, I don't think it's a case for consent. Correct. Do you have third parties? Do you have third parties accessing that data? No. You don't have. So it will be internal data. Unless you have security measures, adequate security measures, then it's a different question. If you have security measures, I mean, you protect your data and no third party is allowed. So if you are sharing that with a third party, then you have to do a risk assessment of the third party, ensure contracts where privacy terms are clearly defined, retention timelines are defined, and definitely, I mean, DPDP applies in terms of retention of data. So if you want to store this data for 100 years, this patient won't live for 100 years. So you need to have a retention timeline. How long I want to keep this data? Regulatory time frame may be there. So maybe 10 years, 15 years down the line, you want to delete that data. So if you have that policy with you, you have privacy notices on your website, that should be okay. You don't have to require specific consent for treating a patient. I mean, patient is in an emergency condition, you want to ask the patient, can you give me consent? I mean, that becomes a challenge. So I think law is very clear on that. Anything regarding health, somebody's life, you don't require consent for that. That comes under legitimate use. There's a specific term for that. That's a legitimate use. You can process the data without taking consent.
Consent is not the
ground of processing. So you don't require a consent for that for treating a customer.
Go in the blanket consent, then you.
Correct.
What you have to make sure that you're not, the hospital is not leaking the data with a third party like diagnostic labs or some other research laboratory. Like
you have a framework around your own ecosystem to protect the data.
So,
Yes. That's your data.
Only anonymous.
I mean, after this, he may say, I don't want to share data.
yeah, he's a collaborator for us, so please keep that. But maybe just adding on to that one thing, right? So just going toward using that in a different domain, we've talked about informed consent multiple times, right? So I mean, I'm sort of the IT support guy for my extended family, and if there's a new pop-up people have memorized how to do something, and if there's a new pop-up coming up, people panic, and they'll do something, and they'll click 10 buttons. So, I mean, the digital literacy in India is very low compared to, Europe. And so when we are talking about in context of informed consent, what would that even mean for a population where in the digital domain, where the digital literacy is so low? And do we have to innovate for that? Or is somebody innovating for that?
I think it's more difficult than what it sounds. Like, I was just thinking about this. So there is an initiative by, I think, central government called eShram or eShrama or something. We basically, for gig workers, we employ a lot of gig workers. So for them, there is a portal where you can register and the government will give you some sort of social security. Not too sure what the social security is. So the government apparently has some targets on this many number of users must be onboarded. So BJP has something and they're not meeting the targets. And I remember this when you said that governments are also not exempt from this. So the government was trying to get the data from like e-commerce companies like us as well. And this went through, like a lot of rounds to see, are we legally required to give it, or can we just say that we are not going to share it? I am not sure if we concluded on it, but it was something that I think it is very difficult because at the end of the day, the data is like clearly for the gig workers good. At least that's what they're claiming, that they'll use it for providing them social benefits. But people are not onboarding and government wants to kind of sort of maybe, like bypass the system and say that you give us the data of, like Flipkarts and Amazons and Swiggy give their gig worker data, we will auto onboard them and then give them goods. So I don't know if it, like similar to the question that he had about health kind of things. I don't know where is that line. I think that is where I felt that this is truly out for, like legal team only, because I couldn't figure out. It's not morally, I could not fit it in my compass. Where does it fit?
So this brings me to this entire point that it's not about personal data anymore. It's about data sets in a more general manner. And I think we can learn something from Europe as well. Europe, when they came out with the Data Act, they did not talk about personal data there. It's purely a data act. They were more coming from the perspective of IoT devices, coming from the perspective of instances like you mentioned. So there's a clear provision there where state can ask private bodies for data sets for exceptional needs, for welfare needs, right? And I was very impressed to see yesterday Namayatri gave their entire data set to the center for very good work. I mean, think about it, right? Namayatri is literally giving their data set where you analyze, find some solution. BMTC is coming there. It's a collaborative effort which is really wonderful. So, as like this case which you've mentioned is aptly covered in the Data Act. In India, hopefully, again, we are always like 5 years behind Europe, so we might have something for that as well. But practically speaking, you will have to give your data to if the government is asking you. You will end up giving the data.
In US,
You
if
can anonymize maybe. Do a little bit of generalizing,
No. This is for something very specific. They want our data so that they can onboard these people. So this is not. This is truly PI data.
Yeah. So government is your vendor in a way, right? You are collecting the data, or you are the controller, but you are the fiduciary. But you have to pass on the data to the government for the welfare purpose. Yes.
in US, if you see, they don't have a federal law on privacy. They've got sectoral laws. HIPAA is there, then there is FINRA is there. So there are a lot of sectoral laws which governs privacy. And CCPA is more of a consumer protection law. Now they have enhanced it to privacy law, Privacy Rights Act. Other states are coming out. So they have left privacy to states. Federal government does not want to make a single law on privacy. So, but again, in US, every company on their website has to write it, I do not sell your personal data. So that's a norm to have a business in US. So that is the level of, it's not always that you have to come with a law. You have to start with self-regulating. Build models.
I mean, so the US system is very, I mean, if you actually see the egregious misuse of data in US companies, despite what they've written, it's mind-boggling.
The system is like that. So there is opt-out.
Right.
We are in a position, this law, our DPDP is opt-in. There is opt-out. You will use your data until unless the customer unsubscribes.
Right.
If they unsubscribe, the Scam Spam Act, immediately you have to respect that. Till the time they don't unsubscribe or opt out, you can send numerous emailers, numerous promotions, no problem. So that's the format they have accepted as a company, as a country. Our law is more of first take permission and then send communications. That's what it is. So there is a cultural difference between two countries, and the legal system is also different.
So maybe one last audience question. So we're running short of time. Actually, we're over time. Thank you for being a very patient audience. Maybe one last question.
GDPR enforced, Europe saw the rise of consent or pay model. Whether you pay for the actual version or you consent that a data is processed and they give you personalized rights. So what are the chances of that happening in India after the DPDP is enforced? And is the consent opted to that, is it legal? Like, it is technically kind of forcing to
Where we won't have any other option other than to consent, or else we cannot use our application. That is the option we have.
I mean,
If we will to see alert-type privacy policy states this. The certain services will not be provided for you if you are not giving the consent.
I mean, that is forced consent, right? Our law calls out for free consent. Now, this is not free consent. Even I agree with you. This is not free consent. And you give something for consent. So that is also not free. So, I mean, lawyers understand that what is a contract? Contract is a free consideration between two, a promise, acceptance, and a consideration. That's what a contract is. And there's free will to enter into a contract. Now, this is not free. So you're inducing or forcing. There is no freedom over here. So that's not a valid consent. I mean, as per the law, right? Now, I mean, this has to be tested before the judiciary. This has to go before the judiciary for a test, where these type of instances will come. It will be challenged before the Data Protection Board and the High Court and the Supreme Court, the constitutional courts. Then only, I mean, it will evolve. I mean, it's very difficult to say today, sitting here, that whether this will happen or not. Somebody is planning from that angle or not. But if you ask my opinion, it is wrong. It's not the correct way to interpret this law. But if somebody has interpreted in that manner, I mean, it is the judiciary who has to take a call whether this can be accepted or not. If you see the track record of judiciary, there are cases of Khadak Singh, very old, I mean, 1960s. And then there was this telephone tapping case. There also, I mean, the Supreme Court has respected privacy of individuals, more of bodily privacy. But Puttaswamy judgment, it's very, very clear that freedom of individual is ingrained in the Constitution. It has to be respected. And, I mean, we call DPDP is not there means there is no law. I mean, a case judgment is law. That is law. If you are not following that, you are violating that judgment. So that is law today.
Okay.
So, I mean, that's the type of, I mean, this is, I told you, I mean, give consent and get 50 coins in your wallet or 50 rupees in your wallet. I mean, you are inducing somebody, luring somebody to give consent. I mean, that's not free consent, right? Consent should be a choice. I can accept, I can decline without getting any benefit for that, right? So, if you are luring somebody to enter into, to give consent, to use the data, you're actually buying the data from the customer, not taking a free will. So, my opinion is it is not correct.
So on that note, I think we've gone a lot over time. The panelists are here. Come down and interact with them. This has been a very lively session, but we need to stop at some point. So people, you guys will be here for a little bit, right? I think they have a lot of questions, so you will get flooded. But please let's thank this panelist once.